For those who already joined it, I would like to introduce our guest. It's Dima, attorney in law and crypto lawyer. Correct me if I'm wrong. And before we start, it would be a good idea you tell us your background a little bit, how your experience related to crypto and what crypto lawyers is essentially about in your life.
I'm basically a lawyer for the most part of my life. Yeah, I started my career at 20, and the first 10 years of it, or 9 years, I was focused on dispute resolution. Yeah, both national in Ukraine and international. And when we settled up our firm, our local firm in Ukraine, and when everything was pretty much settled, I moved a bit to the M&A part, the corporate, not disputes, but corporate matters like acquisition or structure of banking deals, etc. And at that point, it was like. At that point of time, I mean, the crypto was a bit entering, the scenes, at least in Ukraine, at least at that part of the clients that we were working with. And from several occasions, from several cases, I started moving on it and dividing my practice in both traditional litigation and traditional corporate, to also managing something with crypto. What makes a crypto lawyer persistence, because it's an always evolving market, which is comparing to traditional finances is pretty much young, and you always should expect changes, and you always should be aware that you are at one point of time you never know everything that is currently developed or is changing.
And do you think the corporate culture from the legal perspective is different in crypto companies and classical world TradFi?
It depends. It depends maybe on the projects, because at least if you are at some point regulated, like a business or a project, you for sure are in some point active in your legal framework because you need it. Because in other case it will be difficult for you to provide some services, or even impossible. So it is pretty much close with this regard, because you need to structure the company, be compliant with everything that involves your business, and learn as much practically, especially practically, about regulations that you work in.
I think from what I see in the crypto industry, everything is so evolving. So is it just my idea, or it's in reality it's true that in the crypto space it's more rapidly changing and you need to adapt quickly, like super quickly, like with Mika, for example?
I think as I told, a more younger scene, as a I don't know, market part, of traditional finances, like we can tell this already. I think, of course, it's evolving faster because those financial markets have hundreds of years of development, and that's why they are more strict, more traditional, more sophisticated approach. And the evolving market is not always like this, and of course everything is dragged at that place in order to comply, with their vision of how it works. So I agree with you that we can say that it is more rapidly evolving, at least now, and at least for the past I don't know, 2, 3, 4 years.
So good day everyone again. I see people mostly join it, so we perhaps can slowly cut to the chase. So my name is Slava. I am CEO of AMLBot at Purify. It's a crypto compliance related company and blockchain analytics company. Today my guest is Dima, a crypto lawyer and attorney in law. So our topic today is token in everything related to token launch, post-token phase, and so on and so forth. And I would like to start with the following thing. Back in 2021, we launched our own token, the Purify, and we launched it in Hong Kong jurisdiction. We got opinion from the lawyers from Hong Kong. We went through KYC processes on reputable platforms, and this token is still on the market, safe and sound, on the DEXs and centralized exchanges. So my question is, can we do this again, like tomorrow? Or what is even more interesting for me, can we do it when MiCA come into place, when it becomes fully effective? The same pattern we did.
Your question is, can you repeat your experience, basically? Yeah. Start over, like, and do the same.
Something changed from that 2021 or not?
I can't be sure about Hong Kong, yeah, but as far as I know, their regulation was at the point in 2021 already, yeah, and
yes,
there was a necessity to receive a license there for security tokens, and there was no necessity to receive them for utility tokens. Yeah.
Oh yeah, I forgot.
Basically, you received a legal opinion to prove for the regulator, for the committee, yeah, that your virtual assets, your initial token release is not connected to any security token whatsoever. Yeah.
Right.
Answering your question, there is no like it's a blank question, yeah, because in order to answer it more correctly, yeah, you need to understand what token a project tries to launch, yeah, depending on its type, yeah, whether it's a security token, whether it's a stable coin, whether it's a utility token, or a mixed tokens, as someone calls them, that have properties both something from, like, for example, security, yeah, assets storage, and something from utility. But you can repeat the same process, especially if we are talking about the utility, yeah. We can like take away the security and the stable coins, or the EMAT, as they are called under MiCA, yeah. Because there is no legal obligation both for being present in the EU, for such a company, yeah, you just need a legal entity in order to launch such a token, and to receive any license, yeah.
Sorry for maybe I change a little bit my question. So back in the day, we should have legal opinion that our investors, not investors, those who token holders are not from the United States. And my question is, whenever MiCA come fully effective, is it going to be the same for Hong Kong jurisdiction token or not?
MiCA can't do and doesn't do anything to Hong Kong and their regulation. Yeah. So basically, if you start your process from there for the utility token, you will still be needed to receive a legal opinion with regard to the regulation of Hong Kong.
In Hong Kong.
In Hong Kong, if you decide that your token that was issued by a Hong Kong company needs to be listed both DEX and SEX for the European clients, you need to comply with several articles depending on the token in quantity wise by the clients and in quantity wise by the sum of issue. You'll need to comply with several or less articles with regards to the EU. Not to go in deep, you'll need a marketing plan, you'll need a white paper, you'll need a proper communication with the people who buy your token, and a possibility of a return, as they are considered as digital goods there. Yeah. But doing this and applying to the regulator body, depending on the EU member you are doing, and it will cover all the Europe, if everything works with regard to the regulation of MiCA, you can launch the same token from the Hong Kong company, but with regards to the some articles of the MiCA regulation.
So just for my understanding, I can do the same. I can get legal opinion from Gong lawyers. Then in order to be able to sell this token through DEXs and Europeans might be able to buy it, I need to be compliant with some MiCA articles, right?
Yes.
And
Regulation requirements, yeah.
Requirements, yeah, sorry. And those requirements are dependent from the volume of your token, the coin market cap, or what does it mean, the volume? Or
again, in order not to be overly complicated, yeah, as we are talking about the utility token, yeah, the first thing, you don't need any license in Europe in order to issue it, but depending on the initial token offer in term-wise, quantity-wise, for clients, if you like presume that you will sell it for, I don't know, 200 people, it's another digit there, but nevertheless, or less than 200, yeah, and that the market availability will be less than 1 million euro, you don't need to comply with most of the regulations listed under MiCA. If it's another case where there is no like volume cap in clients and both it exceeds 1 million, you need to fulfill these obligations under the MiCA in order it to be comply in Europe and in order to be listed and available for purchase for the EU citizens.
Can you elaborate a bit? What does it mean to be compliant? Some questions pop up in my mind. Shall I register a legal entity in the Europe? Or what does the process like in general look like?
There is an application form for such tokens. Yeah, firstly, you don't need a legal entity. There is no obligation for utility tokens to have a legal entity in the European Union. You can launch it basically from any legal entity. Secondly, you need to follow the guidelines of MiCA. This is what I was talking about, to be compliant with them. Yeah, to do the obligations that they have in it, in order to provide an application to the regulatory body from, like, let's call it MiCA, yeah, the regulatory body of MiCA. It will be in each state, but nevertheless, you need to do like several steps. Let's talk, there are 4 or 5 of them, yeah, as I told. Yeah. Marketing plan, white paper, obligations for clients, digital goods, you need to return them if the client asks in 14 days, etc. If you do this, provide it to the regulator body, it has, I think, 20 or 25 working days to analyze your documents and provide you with the answer that if all is okay and all is with in regulation, yeah, you can list it and you are free to issue it to the European countries.
Right. Gotcha. Thanks.
This differs to security and stable coins. They are another story.
Can you elaborate on those 2 types? Because
also, I think
I explained why I'm asking, because in AMLBot we have a few clients that are stablecoin issuers, and one of them, one of the first, I guess, fully regulated in Luxembourg, I guess. And yeah, it's interesting through which step they went.
I think your clients are currently like doing the proper preparations in order to comply with MiCA next year. Yeah, because for security tokens and for stable coins, the regulation is it's the same. It's MiCA, yeah, but it's completely different. You cannot
completely different. It's completely different story, right?
Yes, not completely different. Yeah, it's the same regulation, the same rules, but the possibility to issue a security token or a like assets related token, yeah, or the e-money or stable coin as we call them, you need to have a legal entity in the European Union. This entity, in the case of security tokens, asset related, should be a credit institution not a banking, yeah, but a credit. It's another like type, because it will hold assets that will be connected to the token price, and depending on the marketing strategy on the assets they hold, they need to keep reserves, they need to provide special regulations inside their company, like monetary policy, segregation, like etc. Yeah, in order for the token to be compliant. So this is basically another step. There is a you need to be pretty much big, yeah, with this regard, because the capital of the company, I think, should be not less than 250 euro, depending on the share assets that will be held.
So
Closer
it's
to
very...
the things, yeah.
sorry.
It's very strict, yeah. It's rather strict. Stablecoin, another like thing, yeah, with this regard. It's an digital token that is connected to the price of certain like euro, yeah, certain fiat currency. You also need a legal entity in the European Union. It should be electronic money institution, yeah, even prior to doing, yeah, any token emission, etc. So you need to be licensed here. You need to have presence,
right?
EMI, yeah. You need a presence here. You need a working company here, and also you need to be ready to follow the regulations of the statutory capital, of your reserves, of the team, of the security issues with regard to the token, etc. So yeah, but this regard, it's a pretty much heavy stake, I think, on the projects, and like as we can see from the news, from like for like Tether, yeah, who are no one really knows exactly, yeah, whether are they doing something or not, but depending on how the sex tell everyone that they will be delisting it since January 2025, yeah.
Rumors, yeah,
no one knows what would happen, but this is the leverage, yeah, basically. This is what I also want to talk about, yeah. For them, they of course big, and I'm not sure, yeah, but I suppose that there will be a way for them that they will do something with their regulation, or they will partner with someone. But this is basically the leverage that is done, not directly, but indirectly to the MiCA, yeah, because all the centralized exchange platforms need to comply and need with MiCA too, yeah, and in order for them to comply, they need to remove Tether, because they don't have the needed regulations here, needed legal entity for them to offer the token, their USDT, yeah, to their clients.
Yeah, so from what you said, presumably they are incorporated in some offshore jurisdiction. I don't know. I'm just speculating on that. But in order to be able be listed on Kraken, for example, European regulated exchange, they need to set up a legal entity here. They need to get all of this licensing, right?
Yeah,
and be compliant with MiCA. Yeah, now it's clear. We have a question from audience, and I read it. Can please the speaker clarify about the volume, if you know, of course, and utility token where the license is required, and where not? Possible with reference to article in MiCA.
I can look for the article. I think it's even. I'm not sure. Yeah, if there is such a necessity, I can take it up a bit. But as I said, it's for sure less than 1 million euro in cap. Yeah, and as for the clients, it's 100 something. I'm sorry. If we want a proper answer, I cannot guess. If there is a second question, you can read it at the moment while I'll look for the first one.
Yeah, the second question is also to you, so I don't want to. Maybe it will take some time, so we can find this article later if it.
Okay.
I believe it's a matter of searching, but there are still these thresholds, right? That was clear.
There is one threshold. It should be offered within 12 months. There is quantity of clients that can acquire it, and there is a market cap in the volume of not bigger than 1 million euro.
Right. Okay. So we already touched this topic regarding those structuring, whether it's utility, security, stablecoins, and maybe some hybrid schemes. Well, perhaps most of the listeners that are interested in the topic, they are rather about utility token. Any thoughts on that? What is utility token? What is the difference, maybe in the short, from the legal perspective again?
The utility token is a token that will provide the acquirer, the person who purchases it, the possibility to receive benefits from the project as a product already launched. So it can be, if it's on-off ramp exchange, less transaction fees. If it's an, I don't know, AMLBot, free checks, anything that the project itself provides services in order to either make the price for them smaller, if you have like several quantities of them, or provide them for free. So basically this token is providing just the possibility to receive service from the product that launched the token. That's pretty much easy in the words. This token cannot provide no voting, no with regard to the project, no shares, no compensation, no possibility like to receive assets from the product activities, etc. So it is limited to receiving services for the launched activities of the project.
Exclusively, and you said it can be even voting. So so-called governance token is also impossible to be utility, right? Because I remember some project has this governance function. So the one who hold our token, perhaps even on 1 inch in their white paper back in the days, there was a statement that whenever you have the token, you might vote for some changes in algorithm. So this is also banned, right? It's impossible.
It's complicated, It's not. I can give you a direct answer, So basically, what they're trying to separate, in my opinion, here, and of course, it's also country dependent, is that the utility can provide the utility, You can have a part of a service or a service from the project that launched the token. You can pay with it, or you can receive a discount with it for the services. Anything that is connected to the project, like an share, they try to separate it to be like security, because it has more, it is closer to the classical financial, like shares or of a company, etc. So why I'm telling this difficult to answer, because you need to look at the whole picture of how it functions in order to be, in order to at least tell on a high level whether there are any qualifying signals that may occur and it may be seen as a security token.
I see. So I imagine it rather also difficult question. It need more time to delve into this topic. But from my first understanding, whether the company states some part of our profit we allocate for buying tokens, that's why the token gonna grow. So this statement is also impossible in regard to be utility token, right? Because
no, you are talking that your company who issued the token buys token. It's another thing.
No, buy from the profit. So from operational profit, we allocate some part of this money to buy token from the liquidity pool. Does it kill the utility? Does it make it security or not?
If the token holders who are not the company, if the token holder has only the possibility to receive service using your token, then you will not lose. If you as a project and because you're talking like a mix a bit, yeah, you're talking that you as a project, if you decide to like reinvest, like for example, yeah, in itself and to issue more, it doesn't add any value to the token, because
Right.
For the client, he still receives service for it and not receive any voting or any type of share with regard to the project. Yeah.
Okay. Let me read another question. Yeah, there is a question from Andrew. In a game project, I believe it's some kind of gamify or whatever, token that represent game currency, allowing to buy, sell goods within the game. Is it still utility token?
Yes, because it's also the service is the game. The game currency is connected to the game, where you can buy like I don't know, cars inside the game, for example. Yeah, but they are still inside the game, and you receive this service. If you're able to receive this service separately from the token, yeah, this is basically the utility token. So yes, I think yes.
Yeah, thanks. So let's make a small step back from the very beginning, from the fundraising strategy. I'm talking about so-called IDO, ICO. It is interesting what implication Mika makes on this process, or what current businessmen need to be compliant with, I mean, KYC, AML, and so on and so forth. If you can dwell into this part of the token.
Mika didn't change anything with regards to how you issue it, yeah, or how you make it to the public, yeah. So it's just a general rules under which you need to fulfill in order for the token to be available in Europe, yeah. So then it doesn't matter. The only thing that matters that it's concerning the centralized, yeah, platforms, that if you list your token with them, they will ask you first to comply with the regulation, because if you do not comply, they will not list it, because they are I'm sorry, they're the first like line, yeah. Basically they will recheck you, because if the regulator like finds out that such things are in the process right now, they can ask the centralized exchange either to remove it, yeah, in a good manner, or to make other actions to them with regards to this. Yeah, so this is the only thing that changed. Everything else, it's pretty much marketing strategy. Yeah, if you think that the market part and your geo is more into DEX, yeah, more into decentralized exchanges, then you can list there. But it doesn't change anything with regard to MiCA regulation or anything else.
Yeah, if we disregard MiCA, still, what is important on that particular stage from the legal perspective? Well, let's say I want to launch token in 6 months. I want to launch it within European jurisdictions. Can you give
within
yeah, okay, within the European jurisdictions? Give us a high level framework. What shall be done prior to launch it?
Again, if we are talking about the utility token, yeah, pretty much everyone was, if the project is like self-respected, yeah, especially by its founders, by its team, etc. Everyone, even prior to MiCA, had a white paper, yeah, and if they like paid attention, it was a good one. Everyone was marketing it properly, yeah, and everyone was communicating with their clients and making proper actions in order for the service of the utility of the company and the overall issuing of the token be a good practice. Yeah, all that MiCA changed is this is now obligatory. Yeah, you just can't like now launch anything, give it to the public and buy it. Now it's obligatory for you to have a white paper that will be reviewed by a regulator. Now
okay.
Yes, now it is obligatory for you to have a marketing plan and to give an understanding to the regulator how the marketing communications is done between you and your clients and your potential clients.
Sorry, they gonna read our marketing plan to some extent?
It's not, no, it's not the marketing plan. They are trying to understand the marketing, not in regard to the plan, but how the communication is done. Yeah, whether you are like truthful in what you are telling. Yeah, in order they need to confirm that the end user, in their opinion, is receiving the information that corresponds the project and its value and what it does. This is what I mean.
I see. For example, if we about to launch utility token, and in our marketing materials, we present it as a stablecoin, for example, right? It's
something like this.
It's a conflict, right?
If you try, your example is a bit like harsh, yeah, but you can also like do several things, yeah, when you can offer in your marketing something that will never be available both in the project, or the token will never have the possibility to acquire such a service from the project. Yeah, so this is
impossible in general, for example.
Yes.
Now I got you. All right.
As for KYC and AML, this is always on the project, you know. Yeah, you independent of MiCA, independent of US or any other regulation, you should have proper procedures with regard to both KYC and AML. Yeah, of course there are like thresholds. Yeah, you can take the risk in some things, but in general, your compliance procedures should be pretty much in place, because you don't want to receive money, or you don't want to provide services for the clients, yeah, or people who are not compliant with anti-money laundering policy or are sanctioned, like etc. Yeah, so this will always be on the project, because not knowing it or not trying not to know it, if you understand what I mean, yeah, doesn't do anything to you, yeah, because it was your responsibility to do that.
Right, now I got you. And regarding ML and KYC policies, correct me if I'm wrong, it's related to fundraising stage, right? Whenever it's token on a decentralized exchange, is no longer our problem.
It's hard. Sorry, yeah, for interrupting. It's not that it's not our problem, yeah. For the most part, it's a DEX problem as a platform, yeah. But there are no means to implement in order this risk to be mitigated properly, if you understand me. So you, of course, no, you are right that when you issue a token and a part of it is on a DEX, yeah, you can't control the person that acquires it.
Right.
Should you control it in general? Yes, you should, yeah. Not with regard to this situation, but in general. And if you know that the person that acquired it does not comply, you should do all the necessary and all the required steps in order to like mitigate this risk with regard to your project and your company. This is what I'm trying to say.
I see. It's in this case, it's a little bit similar to what USDT or USDC does, even though they are stable coins, because they are trade on a free market. But whenever they find something suspicious, they block it right on the blockchain.
Yes.
And again, we are talking about utility token, and I perceive your answer as you still need to do something. You can't like blindly believe.
Yes. If you know, or if you were in a place that you should know about something that was not in the prospect of your anti-money laundering policy, or the prospect of your KYC policy, or the market you work on, you should do it. Yeah. If you don't know and couldn't know, yeah, and we can like make an example of a DEX here, yeah, then it's away from your scope, but you need to be ready to do these actions if it will be in it.
Okay, I have the very last question, but before I have a question from the audience. Could you highlight differences between European and US regulation regarding to utility token launch?
I can't go deep into US regulations, yeah, but in US, I don't know if it's like I don't know the obligations that you need to do in the US, like there are in MiCA with regard to the utility token, but it's close enough, yeah, as far as I understand it. So you need at least a legal opinion there in order to prove that your token is of a utility function. And depending again on the volume of a market cap, yeah, and on the term that you do it, you will have several obligations that are close to these ones, yeah, proper white paper, proper marketing, etc. As United States is a Fed, there are 52 states there, yeah, it will also be dependent where do you consult and how do you move on with it, because it may differ from state to state. Like, for example, it's another example, yeah, it's not about utility token basically, but if you want to work as a money remittance, yeah, when you can transfer the funds on behalf of the clients, you need to receive permission from every state in the United States. You need like 52 acceptance of the regulatory body in order to proceed and work everywhere there, yeah, or manage yourself and work in the states that you have done it. So states here is always a bit, it's not like, it doesn't differ much, yeah, but it's more difficult, but you have a federal level, a state level, and the necessity to understand whether what state you will be involved in and how you will do it. And that's why the United States is always a more expensive project to start, yeah, because as apart from the MiCA, which is the good, what is good with regard to MiCA, it concerns every European Union member, yeah. So whenever you launch your token in the EU, you are sure that you are, if you follow the regulations and if you receive the approval, you can proceed within any state. That differs in the US a bit.
Thank you. And my last question, maybe you wanted to touch upon market making. You already said us about marketing, but what about market making? We've seen those scandals, what happened with market making companies, and we know that almost every project to some extent has market making. So what is new MiCA bring on the table, or nothing new, but it was always here?
I can't comment on the, I think you are concerning to the guys that were recently in custody here. How they're called? I forgot. Godbit, yeah. I can't comment because I have no understanding and no one has, yeah, like at least direct, yeah, what happened and why. So, but I don't think this is a regulatory aspect that we are talking about here. This is the aspect of legal enforcements considering some actions as fraud or fraudly, because there is no fraud in the regulation. Yeah, I think the most important thing here is to prepare your marketing and prepare your making of that marketing, yeah, in good faith. And if you do not manipulate, yeah, if you do not do something connected to unfair trading, I don't think that there is any risk in that, yeah, because
there's no regulation about market making.
I don't think so. I'm not sure.
Okay.
But you see, it's how can you regulate this aspect? Yeah, because it involves diverse actions which may lead to something. Yeah, basically. So there is a plan under which you can perform, and depending on how you react and what you do, yeah, your strategy may change with this regard. But I'm talking about that the main point here is what you do and what your intents were. Yeah, intents. I mean, so if your strategy and what were you doing were aimed to fraudulent activity, you should expect that maybe at some point of time someone will ask you about your strategy.
I see. Thank you. Thanks for your time. Whoever wants to receive consultancy, either from Dmitry or from our team, you can see here. You can see here a QR code. You can open the simple form, fulfill it, and our manager will contact you. And thanks for your time. And see you.
Thank you. Thank everyone. Have a nice evening or day, depending on where you are. Thank you.